Hello everybody, welcome back to my channel Judiciary Possible. My name is Ayushi Dubey and in today's video we are going to continue with our lecture of Arbitration and Conciliation Act. We have studied till section number 17 of the Act. In today's video we are going to cover chapter 5 of the Act, which deals with the conduct of the proceeding. So it will run from section number 18 to section 27. Arbitration and Conciliation Act is also important for your DGS examination. So before moving forward with the lecture, please do like the video, share it with your friends and please subscribe to the channel. Okay, so section 18. Section 18 basically deals with the equal treatment of parties. Basically section 18 is based on the principle of natural justice. So the Arbitration Act provides that both the parties, both plaintiff and defendant, will be given equal treatment. They will be given equal opportunities to represent themselves, to be heard before the tribunal, so that they could make their case. Okay, simple. ज़्यादा इसमें दिमाग नहीं लगाना है. Then we come to section 19. It is determination of rule of procedure. Basically the section says that the rule of CPC, the procedure of CPC and Indian Evidence Act will not be followed in the arbitration proceeding. Why? Because it's a lengthy process. It's a time taking process. It's money consuming process, and in order to cut those things, the act has been made. अगर हम CPC का procedure and evidence का procedure will involve or inculcate in arbitration, then there is no requirement for Arbitration Act, as it will again stretch the matter. Okay, it will take that much amount of time only. So in order to not go to that length of time, the Arbitration Act has been made, and henceforth the procedure of CPC and Indian Evidence Act will not be followed in the Act, and this has been stated in the section number 19. Okay, then we come to section 20, place of arbitration. It is a very important section. Okay, in Balco case, it's a very important case. Balco's case, they have differentiated between the place of the place or seat of the arbitration and the venue of the arbitration. With respect to venue of the arbitration, they have said the geographical area, like India, okay, like Australia. It is the venue, it's the geographical area. The seat is with respect to India में कहाँ? India में Delhi, India में Bombay. This is the place, this is the seat from of which the judicial procedure will be applied. The seat from where the arbitration has been decided to conduct, the procedure of that place will be applied to the proceeding, and hence it is important to distinguish between venue and place. If the venue is located outside India, okay, if let's say it's in US or it's in Singapore, then part 1 of the act will not be applied. Why? Because part 1 is applied on the domestic arbitration and not international commercial arbitration. Okay, so this case is important. Remember the case name. I'll repeat the case name. It's Bharat Aluminium Company versus Kaiser, KAISER, Kaiser Aluminium Technical Services. Okay, 2012 का केस है ये. भारत एल्युमिनियम कंपनी वर्सेस कैसर एल्युमिनियम टेक्निकल सर्विसेज 2012. That basically the distinction between the venue and the place, or place बोलो या seat बोलो, it's almost the same. Still there is a difference, but we don't have to go into that detail for our prelims examination basically. तो जस्ट रिमेंबर दैट कि इस केस में वेन्यू और सीट के बीच का डिफरेंस बताया गया है. ओके, आई विल रीड द सेक्शन also because it's an important section. Section 20, place of arbitration. The parties are free to agree to the place of arbitration in their agreement or in their clause in the contract. They are free to choose the place of arbitration in case the dispute arises. Okay, if they are not able to agree to a place in the agreement, then arbitration tribunal shall decide the place of the proceeding. Okay, and they will take into consideration any inconvenience which the party may face. Okay, if the arbitration tribunal may, unless otherwise agreed by the party, they'll meet at any place which is considered appropriate for consultation among its member for hearing witness, expert, inspection of document, goods or property. Basically they'll agree to a place which is convenient for both the parties, as well as it should be convenient for the expert which may be appointed or the witness which may be brought in for questioning or for production of the document or inspection of the document. So all these things are taken into consideration. If the parties does not agree themselves to choose a place and arbitral tribunal choose the place, they have to consider all these things. Okay, then section 21, which is commencement of arbitral proceeding. Okay, the last line is important in your barrack. Open your barrack. It is arbitration proceeding commences on the date on which a request for the dispute to be referred to arbitration is received by the respondent. Okay, जब एक रिक्वेस्ट डाली जाती है आर्बिट्रेशन के लिए एंड द रिस्पोंडेंट यानी और द डिफेंडेंट एज यू मे से, उनको वो रिक्वेस्ट रिसीव होती है, from that day itself the time for the arbitral proceeding, the commencement of arbitral proceeding starts. Okay, remember this line. Okay, what particular dispute commences on the date on which request for that dispute to be referred to arbitration is received by the respondent. Okay, then उसके बाद से इतने कोई heavy sections नहीं है, we'll just go through it. Section 22 deals with the language. The parties are free to choose the language in which their proceedings shall take place. If they are not able to agree to a language, the arbitral tribunal shall take up the matter and will decide the language of the proceeding. Then we come to section 23, which is a statement of claim and a statement of defense. Okay, statement of claim is made by plaintiff, statement of defense is made by respondent or defendant. You may say respondent. The statement of claim of the parties must contain the facts and the point of issue, the point at which they have dispute or the point of issue, and also they must state the relief or the remedy they are seeking for. उनको क्या रिलीफ चाहिए, क्या रेमेडी चाहिए, वो भी अपने स्टेटमेंट ऑफ क्लेम में लिखेंगे. रिस्पोंडेंट in his statement of defense include his counter in his fact, his counter, and he may also include counter claim or set off. He can include those in his statement of defense. Okay, then we come to hearing and written proceeding. The arbitral tribunal have the liberty to hear oral proceeding for presentation of evidence, for oral argument, or for the proceeding conducted on the basis of document. Okay, arbitral tribunal, they can go for oral hearing in such cases, in presentation of the evidence, in oral agreement, or the proceeding conducted on basis of document. The parties should be given sufficient advance notice of hearing or meeting for the purpose of inspection, डॉक्यूमेंट, गुड्स और प्रॉपर्टी. अंदर इसमें नहीं जाना, बस उसकी हेडिंग याद रखना है. हियरिंग एंड रिटन स्टेटमेंट, आर्बिट्रल ट्रिब्यूनल के पास ओवरऑल हियरिंग की पावर है. सेक्शन 24 में दे कैन हियर द प्रोसीडिंग्स ओरली with respect to presentation of evidence, with respect to any oral argument between the parties, or with respect to any proceeding which is conducted on the basis of any document. Okay, if there is any inspection of document or goods or property, the opposite party must be given a notice and sufficient time to create their defense when such inspection is going on. Okay, now we come to an important section, which is section 25. It is default of a party. Okay, in case a claimant default, the person who is claiming for a settlement in case he is at a default, then arbitral tribunal में terminate the proceeding, वो proceeding वहीं खत्म हो जाती है. In case the respondent is at default, the proceeding continues. Okay, but if any party, either claimant or respondent, they fail to appear at any oral hearing or they fail to produce any evidence, then in that case arbitral tribunal may continue with the proceeding and he may award as per the evidence which is produced before him. Okay, बेसिकली अगर क्लेमेंट फॉल्ट पे होता है तो प्रोसीडिंग टर्मिनेट हो जाती है, रिस्पोंडेंट फॉल्ट पे होता है तो प्रोसीडिंग कंटिन्यू रहती है. इन केस ईदर पार्टी फेल हो जाते हैं अपीयर होने में या फेल हो जाते हैं कोई भी एविडेंस प्रोड्यूस करने में, इन सच सिनेरियो द आर्बिट्रल ट्रिब्यूनल में कंटिन्यू विद द प्रोसीडिंग बट दे विल बेस देयर अवार्ड मतलब उनका जो हम नॉर्मल लैंग्वेज में जजमेंट बोलते हैं, आर्बिट्रेशन में हम उसको अवार्ड बोलते हैं. जब वो अवार्ड अपना सुनाते हैं या देते हैं उस टाइम पे वो उन्हीं एविडेंसेस पे जो उनके पास हैं उसी बेसिस पे वो अपना अवार्ड देंगे. ओके, देन वी कम टू सेक्शन नंबर 26 which is expert appointed by the arbitral tribunal. If there is a requirement for an expert, arbitral tribunal may give permission for the appointment of such expert. Then we come to section 27 which is court assistant in taking evidence. Okay, basically party may apply with the permission of court or arbitral tribunal may themselves ask for an assistance from the court which allow the evidence to be taken and it must be directly produced before the arbitral tribunal. Okay, this completes your chapter 5. इसमें दो सेक्शन सबसे ज़्यादा इम्पोर्टेंट है, सेक्शन 20 एंड सेक्शन 25. रेस्ट ऑफ द सेक्शन इज इम्पॉर्टेंट विद रिस्पेक्ट टू MCQ. इन डिटेल्स नहीं जाना होगा बाकी सेक्शंस में. सेक्शन 20 एंड 25 की डिटेल विद रिस्पेक्ट टू मेंस आपको जाना होगा क्योंकि उससे क्वेश्चंस बन सकते हैं. एंड रिमेंबर द बाल्को केस जिसमें डिफरेंस बताया गया था वेन्यू और सीट के बीच में. ओके, I hope you like the video. With this we complete the conduct of arbitral proceeding. And in case if you have any doubt, please do comment in the comment section and follow my Telegram channel, the description of which is in the comment in the description section, where I keep on posting MCQs and latest information with respect to any judiciary update. Thank you so much.